All right, Miss Wilson, Miss Wilson, how are we proceeding this morning?
I think we're ready on Thompson.
All right. Dominic Thompson.
Correct.
And I know Mr. Goodrich is ready on his sentence.
Yeah, but as you were waiting for the morning, where you were talking.
All right, so we're on the record in docket. We're on the record in docket 24000975. That is people of the state of Michigan versus Dominic Thompson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Thompson. Mr. Thompson is now appears with me and standing to my right.
Sir, you are Dominic Thompson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for exam next week. That is correct, Your Honor.
All right, so the prelim is set for June 7th, 2024 at 8:30. We've held a probable cause conference. Anything else for the record in docket 24000975, Ms. Wilson?
Not for the people.
Ms. Schroeder.
Not for defense.
All right, Mr. Thompson, I'll see you on June 7th, 2024 at 8:30 next week. Okay,
All right,
sir.
thank you.
Thank
And
you.
then, real quick, Mr. Thompson.
And this is the sentencing with Mr. Margolo.
Correct. It's a little bit different. Oh, I'm so sorry. Jeez, I know, right?
All right, so we're on the record in docket 24000703. That's people of the state of Michigan versus Patrick Margolo. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Margolo, who's standing to my right.
And sir, you are Patrick James Margolo, is that correct?
Yes, sir.
Thank you. This is the time set for a sentencing today. Ms. Wilson, is there any restitution on this matter?
There is, Your Honor, and I thought we completed a pink sheet at plea, but I'm seeing in the PSI that there's nothing about restitution. Is there anything in the court file?
No, I don't have any pink sheet.
Okay, I believe the restitution amount was 200, and I can do another pink sheet. Let me
All
just
right.
double check my notes to confirm that.
My notes reflect that Ms. Wilson, I wasn't here, I believe another attorney was filling, but Ms. Wilson requested $150 at the time of.
Yep, it was 150. Yep.
To whom?
Laura Juarez.
And that's Juarez.
Correct.
All right, then I'll circle back to you, Ms. Wilson, once we do the pre-sentence report. So concerning the pre-sentence report, Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with your client, Mr. Margolo?
Yes, we have, Your Honor.
Any additions, deletions, or corrections?
One correction that I noticed at the bottom of page 1, it states that Mr. Margolo was released from prison on September 23rd of 24. And I'm pretty sure that should be September 23rd of 23.
Oh, September. All right, anything else, Mr. Goodrich?
No other corrections, Your Honor.
All right, allocution.
Thank you, Your Honor. Your Honor, Mr. Margolo has served 37 days jail on this case at the beginning of it. He is continuing to be on parole. As stated in the report, he was placed on 2 years of parole in last September, so he's still scheduled to be on parole for over an additional year. He informed me that he's been in good contact recently with his parole officer, Mr. Crowell. having spoken with him yesterday, most recently, as part of parole, he's wearing a tether at the moment, and then doing other parole tasks. So I would ask the court to consider just sentencing him to just 37 days credit for time served, and with fines and costs, because with the consideration that he is, like I said, being monitored by someone else at this time. And due to Mr. Margalow's homelessness, I think it would be very difficult for him to do both probation and parole at the same time. So I would ask the court to just basically let parole handle it at this time.
How much longer is he on parole, Mr. Goodrich?
Well, by my figures, it'd be about 15 months. Does that sound about right?
Ms. Wilson?
It's the court's discretion.
All right, Mr. Margalo, anything you'd like to say to the court before the court passes sentence?
I think between being homeless and with the parole, it'd be hard to be on both tasks at the same time, probation and parole, because same what he's saying, and yeah, so that's what I think.
All right, understand there's going to be some fines and costs and restitution associated with this, so we're going to have to set it out. So there's going to be at least 225. What's the collections issue? 350. So you're going to have a period of time to make the payments. If you don't make the payments, then it'll be a violation of your parole and you'll be bench warranted. So
I have plenty of money.
All right.
I have plenty of money.
All right, we'll just say that up front, so that doesn't become an issue, because you don't want to get caught up in that bench warrant cycle. All right, so this is a sentencing on for the guilty plea on March 28, 2024. For the larceny, $200 to $1,000. The court will assess $100 fine, $100 costs, crime victims' rights fee of $75, state minimum cost fee of $50. That might do it. That's $475. A restitution of $150 for a grand total of $475 to be paid to the city of Lansing, and then we'll refer that to collections. So if you're out now, just get with collections and start that issue, because that'll be the threshold. We'll go past the threshold to refer to collections, which is what we'll do. All right. I'm gonna sentence the defendant to 37 days in jail, credit for 37 served.
So I have to go to jail?
You are not. Yeah. 37 days in jail, you'll get credit for your 37 days served. And then the remaining balance of $475 will be referred to collections. All right. Anything else for the record? I'm not putting you on probation since you're on parole for 15 months. That would be duplicative on some level. Anything else for the record in docket 2400703? Ms. Wilson.
Just briefly, Your Honor, I'm almost completed with the pink sheet, but I recall that there was an issue with the spelling of the defendant's last name in our system, so I just want to make sure I get it correct. Is it M-A-R or M-E-R?
It's M-A-R-G-E-L-O-T.
Perfect.
And if I may approach with that, Your Honor?
You may.
I have a question, one more question, Your Honor. Is there any possibility that I could get a copy of my ID and social security? Any questions?
Not from the court, but you may talk to Mr. Goodrich and he may be able to help you with, you're looking for a regular ID number and a social security card.
Just a copy of my state ID and social security.
Yeah, I don't think that would be made available to the court, but you might.
Right, it's something you have to get to the Secretary of State.
Yeah.
Okay, that's what I was told.
Yeah.
I was just so.
Yeah, I think the ID issue has to go through the Secretary of State, but they may be able to give you a copy of what they've already had. I just don't know. All right.
Yeah, that's what I was told. I'm trying to get an apartment.
All right. All right. So I'm in possession of the pink sheet involved with the $150. That'll be made part of the referral to collections. And I'll put referred to collections. All right. I'm gonna. What's that? Yeah, I assumed. All right. So with all that, you should be all set in this court. You're gonna have to apply to collections or at least make contact with them to start whatever plan that they have for you.
What would that be?
That would be Marquito, right? Yeah. So go to the 6th floor, go right here to the window and they'll set you up. You should probably do that today just to set it up. But you can go to that window today and they'll appoint you to the right person to go to and they'll have all the paperwork. All right. Anything else for the record in 24-00703, Ms. Wilson?
Not for the people.
Mr. Goodrich.
No, Your Honor.
You're all set. Thank you for your appearance today.
Mr. Goodrich, if you're client, you should wait, I'll take the 2 collections.
Okay.
Perfect. All right, Ms. Wilson, where are we going now?
So I believe we're ready on Mr. Seagraves and Ms. Weatherspoon. They are co-defendants and there are 4 files total. I don't know if the court wants to call them all at once. We are doing the same thing on all of them.
All right, so it's Seagreaves and Weatherspoon. I have Seagreaves first.
Okay,
You can call both of those. What are we doing on those files?
we're just leaving it separate exam.
All right, so I think we can call both of them. Call both Seagreaves and then we'll go on Weatherspoon. Mr. Fagelson, you're here on that case.
Mr. Seagraves, yes, Your Honor.
All right.
Both matters.
So we're on the record in docket 24-00522 and 24-01097. That's People of the State of Michigan versus Gregory Seagraves. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Fagelson.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson on behalf of Mr. Seagraves, who's standing to my right today.
And sir, you are Gregory Seagraves, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for exam on both files.
All right, and that's a fair statement, Mr. Feigelson.
It is, Your Honor.
So we'll leave on for prelim for the June 7th at 8:30 date. 8:30 date. So I will see everybody on June 7th at 8:30 on both of these files, 24-00522 and 24-01097, which is, I believe, next week, correct?
That's
Yes, Your
correct.
Honor.
Yep.
So next Friday, and that is the substance of the probable cause conference. Anything else on either one of these files, Ms. Wilson?
Not for the people.
Mr. Fikes?
Nothing on behalf of Mr. Seagraves, Your Honor.
All right, Mr. Seagraves, we'll see you next week. Thank you for your appearance.
Thank you, sir.
There's that paper.
And then Ms. Weatherspoon
Yes,
with Ms. Livingston?
yes. And there are 2 files for Ms. Weatherspoon as well.
Thank you. All right, so once again, we are on the record in dockets 24-00523 and 24-01096. That is People of the State of Michigan versus Liana Weatherspoon. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Livingston.
Good morning, Your Honor. Katie Livingston appearing on behalf of Ms. Weatherspoon, who's standing to my right.
And ma'am, you are Liana Weatherspoon, is that correct?
Yes.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe we're going to leave this set for exam on both files.
All right, and that's a fair statement, Ms. Livingston?
That is, Your Honor.
All right, so we'll leave on for the preliminary examination, which I would assume is the same.
Same time.
Same time. What time?
It
That's
was June 7th at 8:30.
June 7th at 8:30. Eight thirty. There's one file that was a little bit different. That was the first file. That was 24000523. So we've reset. So all four will be set for next Friday at 8:30. Is that correct?
That is correct.
That's correct, Ms. Livingston?
Correct, Your Honor.
All right. Anything else for the record in docket 24011096 or 24000523, Ms. Wilson?
Not for the people.
Ms. Livingston?
No, thank you, Your Honor.
All right, Ms. Witherspoon, we'll see you next week, next Friday, okay? That's all for the record on those two files.
Thank you, Your Honor. Have a nice day.
Thank you.
Wait for a minute, I'll get a report.
I think Mr. Carter's back. Okay. That's what he's doing. Okay.
So, Mr. Carter, are you ready to proceed on your case?
Yes.
All right. That's Ms. Polda?
Yes.
All right, so we're on the record in docket 24-01493. That is People of the State of Michigan versus Angeline Keevan. Will the parties please introduce themselves for the record? Ms. Polda.
Thank you. Sarah Pulled on behalf of the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Miss Keevan, who is present through the jail Polycom system, and we would ask the court waive her personal appearance.
All right. And ma'am, you are Angeline Keevan, is that correct?
Yes, sir.
All right. You can hear me all right, Ms. Keevan?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Polda, how are we proceeding, or would you like to defer?
Your Honor, I believe that it's the defendant's intention to unconditionally waive her right to have a preliminary examination. The people would also unconditionally waive their rights as well.
Is that a correct statement, Mr. Carter?
Moved, Your Honor. I've had the opportunity to discuss with my client what a preliminary exam is. It's basically a probable cause evidentiary hearing. And for strategic reasons, my client wishes to waive her preliminary exam and proceed to circuit court, where this case will be disposed of one way or the other, and negotiations will still continue.
All right. May I inquire of your client of a waiver of the preliminary examination, Mr. Carter?
Yes, Your Honor.
Thank you. Ms. Keevan, you understand you have a right to a preliminary examination. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney David Carter, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case bound over to circuit court where negotiations are going to continue. Is that a correct statement? Do you wish to waive your right to a preliminary examination and have negotiations to continue?
Yes, sir.
And the people also waive their right to a preliminary examination?
That's correct, Your Honor. Thank
All
you.
right. I'm in possession of the bind over documentation. I will let Ms. Polda sign for the prosecutor's office. Ms. Polda, you get a new job
Yeah,
description also. And then I can sign via Zoom with authorization for Mr. Carter. And Mr. Carter, you can get authorization for your client to sign any documentation since we're doing this by Zoom. Mr.
Yes,
Carter.
I'm in the courtroom, so I'll step in and sign off.
All right. And then you can sign on behalf of your client if you choose.
Yes, thank you, Your Honor.
All right, thank you.
We're all set.
We are. Mr. Carter's going to sign on your behalf. Unless there's anything else for the record on 24-01-493, Ms. Polda.
Nothing further, thank you.
Mr. Carter.
Nothing further. Thank you.
All right, thank you. You're all set. Ms. Keevan, Mr. Carter's gonna sign the bind over documentation. Your next date will be given to you by Mr. Carter in circuit court. Your time in district court is done. All right, ma'am?
Yes, sir.
All right, thank you. Mr. Carter, see, sign that.
Make sure you have a sign up on the corner.
Get him out.
On the tablet, would you please identify yourself from the Union County Jail? That's you, sir?
Rashad Walsh.
Rashad Walls.
No, I don't think his attorney is in here.
All right.
Rashad.
All right. Mr. Walls, just let everybody know that we're getting a lot of feedback from that jail tablet. So you, just so everybody knows that the entire courtroom can hear what's going on in the background. All right. All right.
Okay.
Yeah. You guys have a hang out like you.
We're gonna do the two on this side, please.
That's what it
Hey, bro, can you see me? Can you hear me? Oh.
Hold on the Samsung. I'm going to identify you in a second. The entire courtroom can hear you, so you may want to cease talking. So we'll leave this on for June 7th at 9 a.m. in regards to the preliminary examination. at the probable cause conference. Anything else for the record in 24-01050, Ms. Wilson?
Just briefly, Your Honor. There's been some discrepancy on the spelling of the defendant's name. I've seen it with an M on the end and the N on the and an N on the end. If we could clarify that real quick.
So,
And so,
Solomon.
so it's correct the way it is now.
okay, so I have it as RAPHAEL Najee NAGAEE Solomon SOLOMON.
Correct.
Okay, all right. All right, with that clarification, anything else on the probable cause conference, leaving it on for prelim for June 7th at 9 a.m., Mr. Silverthorne?
Oh, Your Honor.
All right, Mr. Solomon, we'll see you next Friday at this
Okay.
time, okay?
Right.
Sir, on the Samsung, would you identify yourself?
This is Eric Brooks.
All right. And Ms. Schroeder's your lawyer, sir? No.
I believe he's the one, Mr. Kareem Johnson filed a substitution at like 5:40 last night.
All right. So we received an appearance late last night for you, Mr. Johnson. It's Kareem Johnson is your lawyer, sir?
Yes, that's correct.
All right. So stand by. We'll wait Mr. Johnson's appearance.
Yeah, and to clarify, I don't know if he's actually filed an appearance. I believe he's at least confirmed with the public defender's office that he's taking it as conflict
All
counsel.
right. We'll wait to hear from Mr.
Yeah.
Johnson. We're waiting for Mr. Daniels.
I think we're waiting on, because there's a co-defendant case for
Yes.
that, we're waiting on Mr. Hinton, who's not, I don't see him on one of the tablets from the incoming yet this morning.
No.
Um,
So did you need a minute to?
I believe we may be ready on Bogle, which is Miss Wanji's client.
All right, Miss Wanji, are you ready on Joshua Bogle?
I am, Your Honor.
All right. So we're on the record in docket 24-01486. That's people of the state of Michigan versus Joshua Bogle. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
Miss Wanji.
Good morning, Your Honor. Melanie Elby, attorney for Mr. Bogle, who's appearing by Zoom.
Thank you. And sir, you are Josh Bogle, is that correct?
That is correct.
All right, you can hear me all right, Mr. Bogle?
I can.
Thank you. This is the time set for a probable cause conference. Miss Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for exam.
And that's a fair statement, Miss Wanji?
It is, Your Honor.
All right. So at the probable cause conference, we'll leave on for exam for June 7th at 8:30. Anything else for the record in docket 24-01486, Miss Wilson?
Not for the people.
Miss Wanji.
Same for the defense, Your Honor.
All right, Mr. Bogle, we'll see you on June 7th at 8:30. That's a week from today at 8:30. All right, sir?
Yes.
All right, that's all for the record, 24-01486. Thank you, everybody, for your appearance.
Oh, yeah, okay, thank you.
Sir, in post 2 from the Ingham County Jail, could you identify yourself? Yeah. What's your name, sir?
You might not be connected to audio.
Yes, we just can't hear. Say your name again, sir, for having trouble hearing you.
Derek Daniels.
Oh, I've got your name. From the Ingham County Jail, post 2. You raised your hand previously. That's you. What's your name, sir?
I think Mr. Cornish just identified him as Mr. Louis Henry
All
or
right.
Hernandez.
Not my client, but
But yeah, so
All right.
I believe that's what I interpreted his mouth movements to be.
Right. We still
So I
have an
think we're
issue.
waiting on his attorney.
right, so we're on the record in docket 23-02806. That is People of the State of Michigan versus Zarek Daniels. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson.
Mr. Freeman.
Thank you, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of Mr. Wilson, who was also present, standing to my right.
And sir, you are Zarek Doman Daniels, is that correct?
Damon.
Damon, all right, thank you. This is the time set for a sentencing in the matter. Initially, Ms. Wilson, is there any restitution in this matter?
There's not, Your Honor.
All right. Mr. Freeman, you had the opportunity to go through the pre-sentence report with your client, Mr. Daniels.
I did, Your Honor. Thank you.
Any additions, deletions, or corrections?
We found none. Thank you.
Allocution of Mr. Freeman.
Thank you again, Your Honor. Essentially, I'm going to ask the court to follow the recommendation of the probation department. I think it appropriate in the interest of full disclosure that I now divulge to the court and to Ms. Wilson my conversation earlier with Mr. Daniels having to do with the outstanding circuit court matter in Livingston County. He indicated to me that he was recently sentenced on that matter. It is closed as far as that circuit court is concerned. He was sentenced to a straight jail term. I wasn't quite sure if it was 4 months or 6 months, but in any event, he will not be on probation in Livingston County, if that makes any difference in the court's sentencing decisions this morning. He is currently, of course, serving that sentence. As far as allocution is concerned, Your Honor, I'm always pleased as a criminal defense attorney, and particularly as part of the public defender office, to read the probation department indicate that a term of probation appears appropriate for the defendant. He's in need of structure. Probation could provide that structure. He would benefit from engaging in a program that focuses on his thinking patterns and improving his life situation as a whole. And of course, I wholeheartedly agree with that. Therefore, on behalf of my client, I am respectfully moving the court to sentence him to a term of probation and follow the remainder of the suggested terms and conditions of probation, if that would please the court. Thank you.
Thank you. He would start any probation after the release on his Livingston County sentence, I would assume.
I would assume that.
Yeah. And what was the sentence out of Livingston? What was that straight jail sentence?
How much time did you get in Livingston? 4 months or 6 months? You said you're out. Five. Your update is in November, did you say? It sounds like 6 months, Joe.
All right. All right, Ms. Wilson, anything on this matter?
I could just have a brief moment, Your Honor.
All right.
I would leave it to the court's discretion. I will note just for the record that it appears that probation attempted to reach a victim on this matter. I believe that was the person that observed this event and reported it to police. I've spoken with him, and just for the sake of the Crime Victim Rights Act, his biggest thing here is he thinks the defendant needs some help. So I just want to make that clear.
All right, well, there is. I'll follow the order of probation for that reason, because I do believe that probation will provide structure and will provide some help, but it's probably not going to start till after he gets out of the Livingston County sentence. So I'll order at this time that this is for a guilty plea on March 28, 2024 for indecent exposure. The defendant is to spend 180 days in jail beginning May 31st, 2024. Credit is given for 88 days previously served. I'm going to suspend the 92 days upon success, suspend the remaining 92 days upon successful completion of probation. We'll set fines and costs, 200 fine and 200 costs. Crime victims' rights fee of $75, state minimum court cost fee of $50, and then probation. I'll put you on probation, sir, we'll walk through your requirements for probation. For 8 months, $30 per month for $240. So I'll give you a grand total on that. So that's $765. You're placed on 8 months of probation. Yeah, you can, that'll be 30 months per probation. That is okay for Zoom oversight. So you'll be explained that by the probation office. No assaultive or threatening behavior, no use of possession, alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs or urinalysis as directed. No bars or nightclub. Part of your probation will be to complete and provide verification of what's indicated as moral recognition therapy, which indicates that it's a program that you'll have to go to as part of your probation. Not to purchase or possess any firearms, ammunition, or weapons, and obtain, maintain employment. I'm going to indicate for the record in an other that the defendant is finishing a sentence in Livingston County in November of 2024. That's your understanding, Mr. Freeman?
It is, Your Honor. Thank you.
Part of the reason part of the reason for this is district court can be helpful. Okay, and so take advantage of that. Take advantage of the help that we're here to provide. I'm not ordering any jail time at this time because you got to finish your time in Livingston County, but you can take advantage of whatever programs we have in order for the victim who indicated that you get any help you need. All right, sir? All right. Anything else for the record in docket 2302-806, Ms. Wilson?
Not for the people.
Mr. Freeman?
No, Your Honor. Thank you.
Thank you. All right, you're all set, Mr. Daniels. Your probation probably won't start till after you get out of Livingston County, but good luck to you, sir, okay?
I have a question.
Sure.
Do you know what time, or like, is there like a date that I have to give you guys?
What I'm going to do is I'm going to refer this to probation, and they'll contact you in Livingston County because your out date will really be up to the county, but then they'll require you to come in and to meet with them to start your 8 months probation. Okay. All right. All right. Anything else on the record, Ms. Wilson?
Not for the people.
Mr. Freeman?
No, Your Honor. Thank you very much.
All right. You're all set. Thank you for your parents today, sir.
Right here while you sign your order.
JLS, just one sec. It's not too. You and you can take it back. Do we need anybody else at the jail?
No, Your Honor.
All right.
Judge, I'm also pinch hitting. I have a Mr. Bentley, but I believe that he's going to be a no-show.
All right, that is Miss Donnelly's case?
Right.
All right. That was scheduled for 9. All right, we can call that case.
Thank you.
That was set for sentencing today. And I believe Mr. Bentley did not appear for his pre-trial.
That's correct.
Okay. All right, so we're on the record in docket 24-00794. That is people of the state of Michigan versus Jeffrey Bentley. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Freeman.
Stephen A. Freeman, Your Honor, Assistant Public Defender on behalf of Mr. Bentley.
This is time set for sentencing today. It was scheduled for 9 o'clock. It is now 9:26. The court will indicate that Mr. Bentley did not appear for his probation interview on April 4th and has two active bench warrants out of the 16th District Court and has an active bench warrant out of 62A District Court. So it's not a surprise today that Mr. Bentley has failed to appear for sentencing. I do not see Mr. Bentley in the Zoom courtroom. Make sure everybody's out of the waiting room. And then Mr. Freeman or Ms. Wilson, if you want to call the hallway just quickly.
Yep.
But I believe that the defendant failed to appear for sentencing. Ms. Wilson, you've probably been up and down these hallways.
Everybody knows my face now.
They do. How do the people wish to proceed on the fail to appear?
Thank you, Your Honor. I would be requesting an immediate bench warrant.
Any comment on the immediate bench warrant, Mr. Freeman?
No, Your Honor.
All
Thank
right. That's all for the record. 24-00794. Court will issue an immediate bench warrant for the fail to appear for sentencing. We're all set, Mr. Freeman. Thank you.
Thank you very much, Your Honor.
Would you mind grabbing that one?
Yes. Come all the way over your process.
That is Mr.
Trying to figure out why Louis is here.
Like the next talking.
I was trying to see who's
I think it's Sarks, maybe? And
He's in,
Louis.
he's on judge.
Yeah, he's in Judge Ward, yeah.
Mr. Sarks just emailed and said, sorry, he's stuck.
Oh,
Just trying to help out.
I'm ready.
On.
Miss Henry, she's scheduled for 8:30.
All right.
No, you're good.
Wanna go
Yeah,
on?
I'm ready on Miss Henry.
If,
All
if,
right.
if we're good for it, I can,
Yes, I'm ready.
for Miss Henry, okay, just a minute. Get her. All right. Goodness.
All right. So we're on the record in docket 24-01355. That is People of the State of Michigan versus Jamisha Henry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Assistant Public Defender Aaron Schroeder on behalf of Miss Henry, who appears by Zoom this morning.
And ma'am, you are Jamisha Henry, is that correct?
Yes, sir.
And you can hear me all right, Ms. Henry?
Yes, sir.
All right, thank you. This time set for a probable cause conference. Ms. Wilson, how we proceed?
Thank you, and I think we're gonna leave this set for exam.
And that's a fair statement, Ms. Schroeder.
Yes, yes, Your Honor, with some continuing negotiation, but yes, leaving set for exam. Thank you.
All right, so we'll leave on for June 7th, 2024 at 8:30. So we've left on for preliminary examination on June 7th at 8:30. That's next Friday. Anything else for the record in docket 24-01355? Ms. Wilson.
Not for the people.
Ms. Schroeder.
Not the defense.
All right, Ms. Henry, we'll see you next week, the next Friday at 8:30. All right, ma'am?
Okay. Thank you.
Yeah, you should be all set. Thank you for your appearance.
Brooks is on.
So we're on the record in docket 24-01528. That is people of the state of Michigan versus Brandon Labrie. Will the parties please introduce themselves for the record? Mr. Crino.
Good morning, Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Mr. Cornish.
Good morning, Your Honor. May it please the Court Deputy Chief Public Defender Steve Cornish on behalf of the defense.
And your client is not here, but we're waiving his appearance. Is that correct?
That is correct, Your Honor. So far to date, my client has not left his cell due to his competency issues.
Right, and that's something we're going to address today. Mr. Crino, you waived the client's appearance today based on the inability on the petition and the inability to at this point, we don't know if he's left his cell or not.
Your Honor, thank you. Based upon the contents of the petition and the representations of Mr. Cornish, we would waive the defendant's presence here this morning.
All right, thank you. So this is the time set for a probable cause conference. Mr. Crino, how we proceed?
Your Honor, thank you. The court has correctly noted this is the date and time set for a probable cause conference in this matter. Your Honor, the people are ready to proceed to preliminary examination. I have had an opportunity to speak to Mr. Cornish. Mr. Cornish has indicated that he will be making a motion this morning to refer his client to the Forensic Center for an evaluation of both criminal responsibility and competency based upon the contents of the petition and documents that he filed. Your Honor, we think that's an appropriate recommendation here this morning. The people have no objection, and we think that good cause exists to adjourn the preliminary examination based on that request. So I'll defer to Mr. Cornish, Your Honor. Thank you.
All right, Mr. Cornish.
Thank you, Your Honor. Everything that Mr. Crino has stated this morning is truthful and accurate. I have presented that last night to the court and to Mr. Crino, the petition packet, and a fresh copy this morning with signatures on it for the judge's review.
All right, thank you. For the record, I had the opportunity to look at the petition for referral to determine defendant's competent to stand trial. With the understanding of the prosecutor in this matter, based on representations, I'm going to sign the order for competency examination concerning this matter on 24-01532. And I'm going to sign the order for evaluation relative to criminal responsibility concerning this matter 24-01532. So I'll grant your motion. I've signed the orders for petition. And I have all the paperwork in the file. I will indicate before the Register of Action that the petitions in order were signed. And we will place this in abeyance until we're able to get a report from the Center for Forensic Evaluation.
Thank you very much, Your Honor.
Thank you, Judge. Let's get a date just so we can keep track of Mr. Labrie, because I'm afraid if we don't, it'll get lost in the evaluation.
So it's essentially set up for a review date, Your Honor, pending the
Right,
competency
yeah.
evaluation. I think that's a great idea.
Yeah, so let's do a review date. I would think 60 days out, maybe 30 days out.
I would think at least 60 based on the time frame we're getting from the Center for Forensic.
Yeah, so 60 days out review date for. We'll make sure this fits with both of your trial schedule. Well, August 1st work.
For the people, yes, Your Honor. Oh, yes, for the people. Thank you, Your Honor.
All right. Mr. Cornish?
I believe that will work fine. Thank you.
All right. August 1st, 2024 at 8:30. All right, we will wait to hear for the reports, and we've set it for control date. Anything else for the file 24-01532, Mr. Crino?
Your Honor, thank you. Nothing for the people.
Thank you, Mr. Cornish.
Nothing for the defense. Thank you, Judge.
All right, you're all set. Thank you for your appearance.
We're gonna roll the Zoom card over in front of his, as soon as Mr. Walls is done. Okay, I will let the judge know. Thank
All right, Mr. Walls, we'll call your case. We're on the record in docket 24-01518. That is people of the state of Michigan versus Rashad Walls. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Walls. I'm appearing in person. Mr. Walls is appearing by Zoom, by Polycon from the Union County Jails.
Thank you. And sir, you are Rashad Deshaun Walls, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Walls?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think we're gonna leave this up for exam.
And that's a fair statement, Mr. Sarts.
Yes, Your Honor, but may I just be heard on bond briefly?
Absolutely. So we'll leave on for preliminary examination for June 7th, 2024 at 9 a.m. And then Mr. Sarts, you'd like to be heard on bond.
Thank you, Your Honor. Mr. Walls posted his bond. He paid the necessary money. However, he's been unable to be released because as a bond condition, victim notification was required. JSG currently does not have a good valid number for the complaining witness. It's my understanding that Prosecutor Wilson had forwarded the phone information that she had. However, that appears to be a bad number. JSG has been unable to verify her phone number. As a result, Mr. Walls has been unable to be released due to this issue. Respectfully, Your Honor, I would simply request a modification of the bond, leave the hot zone in place, just simply drop the victim notification requirement. That would allow him to be released. That would allow him to stay away from the last known address. And obviously, if the contact information is no longer valid in terms of the phone number, perhaps that would also lessen any possible risk of any contact too between the parties. So, Your Honor, respectfully, I would just ask a small modification at this time to drop that requirement because that appears to be the issue from keeping Mr. Walls out, even though he has posted his bond.
Thank you, Ms. Wilson.
Thank you, Your Honor. Yes, JSG has contacted me, and I believe, the court through the court reporter about this issue. The phone number that they have for the victims, is the same phone number I have. We've run into this issue before, with the victim notification. Usually when there's, victim notification on bond, there's a caveat of if possible. It appears that was not put in place here.
Yeah, the magistrate place, if necessary, which is
So I guess
either.
I guess it's interpretive.
Yeah.
So I will leave it to the court's discretion. I do still want that tether in place. But at this point, I don't have a good phone number, so I don't think notification is possible. So as long as the tether is in place, I'll leave it to the court's discretion as to how we want to modify that language.
All right, so I'm gonna place, so at this time, we don't have the victim's number, and we don't have the victim's, we don't have an adequate number or a address.
We have her last known address, Your Honor, and I have no reason to think that the address is no longer good. It's based on some digging I've already started to do in the case. It's my understanding that the victim may have changed her phone number, and we just simply don't have the new one. I'm going to be requesting follow-up to get the phone number, but as of right now, we do not have the new number.
All right, so is that Everett Drive address still the?
I believe that is the last known one we had.
So we will have a zone notification. That's in regards to the Everett Drive address. So zone notification, we can't, I think it's fair, we can't do victim notification because we don't have an address for the victim or a working number for the victim at this time. So I will modify the bond to read zone notification. Victim notification is not necessary because there's no adequate number or address for victim at this time. And so zone notification will be in regard to the Everett Drive address. Anything else on the record in docket 24-01518, Ms. Wilson?
Not for the people.
Mr. Sark.
Nothing further.
All
Thank
right,
you.
thank you. Mr. Walls, we've changed it from victim notification to zone notification in order to modify your bond conditions. That's all for the record, 24-01518. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Thank you.
Thank you.
This poll has been around here for a long time from Mr. Tomlin,
So who is that?
Domini is possibly still in a breakout. And that's what Mr. Henry.
Don't mind.
Yes, yeah.
It's going to be put Polycom.
Don't worry about it.
Polycom units down.
We've already
They're
done.
gonna try to cancel it, and then cancel.
Yeah. He doesn't have to be present because that was we waived his appearance.
I told him not to worry about it.
So Mr. Walls, you're all set whenever they make those arrangements in the jail. All right, Mr. So Mr. Domine, would you please identify yourself?
Yes, I'm right here, sir.
All right, thank you. Let's go on that case. And who's Mr. Abbott?
He is on Zoom.
There he is. All right. All right, so we're on the record in docket 24-01494. That is people of the state of Michigan versus Grant Domine. Will the parties please introduce themselves for the record? Ms. Polda.
Thank you. Sarah Polda on behalf of the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Ammett with Ingham County Public Defender's Office representing Grant Domine. We're both appearing by Zoom.
Thank you. And sir, you are Grant William Domine, is that correct?
Yes, sir.
Okay, and you can hear me all right, Mr. Domine?
Yes, I can hear you.
All right, thank you. This is the time set for a probable cause conference.
Set on
Ms.
set.
Polda, how we proceed?
Thank you, Your Honor. I understand that the defendant will be unconditionally waiving his right to have his preliminary examination in this matter. The people will also unconditionally waive their right as well.
All right, and is that a fair statement, Mr. Abbott? Your client intends to waive his right to a prelim today and have negotiations continue?
Yes.
All right. May I inquire of your client, Mr. Domine, of his waiver of the prelim, Mr. Abbott?
Yes, Your Honor.
All right, Mr. Domine, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You are represented today by Attorney John Abbott, and he would be present at that preliminary examination to contest any charges or cross-examine any witness brought against you by the people of the state of Michigan. It is my understanding it is your wish and intent today to waive your right to a preliminary examination, have negotiations continue to circuit court. Is it your wish today to waive your right to a preliminary examination?
Yes, sir. Yes.
Thank you. I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And the people also waive their right to a preliminary examination, Ms. Polda?
That's right, Your Honor. Thank you.
All right, and I will provide the paperwork for signature. So Sean, if you provide this, Ms. Polda, or Ms. Wilson can. And then Mr. Abbott, do I have authorization to sign on your behalf the bind over documentation?
Your Honor, I can just walk down the hall and sign that myself.
All right. All right. Yeah, that makes more sense. And then you can sign on behalf of your client if need be. All right, sir?
I will. Thank you.
All right. Anything else for the record in 24-01494, Ms. Polda?
Not from the people. Thank you.
Mr. Abbott?
Nothing from the defense. Thank you.
All right. Thank you. You're all set. Thank you for your appearance today. I'll indicate that today was the date of waiver. And then Mr. Abbott will be in a few minutes to sign the bind over documentation. You're all set, Mr. Domine. Your time in district court is done. You'll be waived over to circuit court for the cases to continue on this case. You'll get your next date from Mr. Abbott, your attorney. All right, sir?
Yes, sir.
All right, you're all set. Thank you for your appearance today. Thank you, Ms. Polda.
Thank you.
Judge, how are you?
Good, how are you?
Just coming back to see, well, I was with Sarah, but it's going well.
Good, good. We're all intimidated by the presence of the elected prosecutor here.
I know, he's so intimidating, right?
Me
When he
especially
sits
right here.
I'm like, when we see him in our court, we're like, oh gosh, are we?
Did you happen to hear Miss Wilson? So, sir, you are Mr. Hernandez LaRosa, is that correct? You still having trouble with the mic?
Yeah.
And you're gonna talk, you'll let him know that this has been left on. Thank you, Mr. Abbott.
Yeah, yes, Your Honor. Yeah.
Mr. Sarge requested an interpreter for the prelim, and I think he can hear us. I just
All
don't
right.
think we can hear him.
Yes, yeah, he can hear us, Your Honor.
All right. And in regards, we'll place it on the record. We did order an interpreter for the prelim at your request.
Thank you. Did you hear that, sir? We'll have an interpreter for you at the preliminary examination. He's nodding.
Right.
Thank you.
All right, so we're on the record in docket 24-01527, people of the state of Michigan versus Luis Hernandez LaRosa. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Hernandez LaRosa. Mr. Hernandez LaRosa is appearing by Polycom from the Ingham County Jail this morning. I'm appearing in person.
All right, and I'll indicate what we've done for the record. Mr. Hernandez LaRosa, I know that's you and you can hear me. We're having some trouble with the mic, with your mic. So go ahead and raise your hand if you are Luis Hernandez LaRosa. All right, you did that fairly quickly. All right, thank you, sir. So he is here, he is present. It's just a matter of technological issues. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. We're going to leave this up for exam.
All right. Is that a fair statement, Mr. Sarks?
Yes, Your Honor, and we'll have a Spanish translator available
All
at
right.
the preliminary examination. Thank you.
So we will reset for June 7th, 2024. I shouldn't say reset. We'll leave on for June 7th, 2024 at 9 a.m. And a Spanish language interpreter has been ordered on the file. For the June 7th date. Anything else for the record in 24-01527, Ms. Wilson?
Not for the people. Thank
Mr.
you.
Sarks.
Nothing further, Your Honor. Thank you.
All right, Mr. Hernandez LaRosa, we'll see you next week at 9 a.m. on Friday. Thank you for your appearance today. What did we have? That was, so we had Mr. Brooks, who was here. I don't know what happened to him.
Is he
Oh,
still,
he's
is he
right
in the
here.
breakout room?
Right. And then Mr. Sarts, did you have anybody else?
Yes,
He is
Mr.
a
Claiborne,
sentencing.
we're good.
Claiborne?
Sentencing, he's here. We have the pre-sentence report already.
All right, let's go on, Mr. Claiborne. And I just brought in Mr. Brooks. He came back on the Samsung. And so let's do the sentencing and then we'll do Mr. Brooks. All right, so we're on the record in docket 24-00716. That's people of the state of Michigan versus Adonis Lewis Claiborne. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Claiborne. Mr. Claiborne is present. He's standing to my right.
And sir, you are Adonis Lewis Claiborne, is that correct? Thank you. This time set for sentencing. Ms. Wilson, is there any restitution on the matter?
There's not, Your Honor.
All right, I'll circle back for any comment. Mr. Sarts, have you had the opportunity to go through the pre-sentence with your client?
We have, Your Honor, no additions, deletions, or corrections to the report.
Thank you. Allocution, Mr. Sarts.
Thank you, Your Honor. Respectfully, I would request the court follow the recommendations in the pre-sentence report here. Mr. Claiborne is very sorry for his conduct. He understands that he needs to work on better ways to work through relationship challenges and do a better job of managing his temper in the future. He's very sorry for what happened here, but he's learned from the experience. He has a good job. He has a stable place to stay. He's been staying out of trouble since he's been out on bond. To the best of my knowledge, there's been no additional allegations of any sort of illegal contact or anything else, Your Honor. He's been keeping his distance from the complaining witness here. Respectfully, he's an excellent candidate for probation. He'll make sure that he follows all the court's orders. Thank you.
Thank you. Any comment, Ms. Wilson?
Thank you, Your Honor. I do see that the victim impact statement was attached to the PSI. Just want to confirm that the court has had an opportunity to review it.
Yes, I've had the opportunity to review it, and it is attached to my PSI.
Perfect. And in my last contact with the victim, the sentiments that she's expressed in that statement are still her sentiments today.
All right. All right, is Mr. Claiborne, any comments you want to make to me before the court passes sentence?
No.
All right. Well, I mean, this is, I'm going to sentence it pursuant to the probation report that's been indicated, but there's also an indication from the victim impact statement that you should, I mean, essentially it's you should take advantage of what district court has to offer. We don't help everybody, but we're able to help. And any program that we have is meant so for the main purpose so this doesn't happen again. All right. It was clear to me that the victim impact statement that it was this was not to be punitive in nature. It's more to be as helpful as it can be to you. And that you know, and that I think that goes a long way. All right. So this was a plea to count 2, which was the domestic violence on March 28, 2024. I am going to sentence the defendant to 2 days in jail, credit in jail beginning on today's date, which is May 31st. Credit is given for 2 days previously served. I'm going to suspend 45 days upon successful completion of probation. So that's kind of the carrot, okay? Or that's kind of the stick, I should say. That's held over your head so that you can finish probation, and that's the time you're looking at. All right, 45 days. That's not an issue if you continue what you're supposed to do on probation. All right. So there's no upfront jail in this matter. You're given credit for your time previously served. I am going to indicate that there's $250 fines, $250 costs, crime victims' rights fee of $75, the state minimum court cost fee of $50. Probation is set for 12 months by Zoom. Okay, you can attend by Zoom. Probation at $30 a month for a grand total of $985. No contact with the victim in this case, Kishana Morgan, you should not be within 2,000 feet of where she lives, works, goes to school, or without the consent of this court. Even if she says it's all right, the only thing that can trump this order or can magnify this order or set this order aside is another order I sign. So that's just a way of keeping yourself safe. Okay. No assaultive or threatening behavior, no use and possession of alcohol, marijuana, or controlled substance without a prescription. I will allow if you present a valid medical marijuana card, which is a prescription card, I will allow that as a prescriptive medication. Okay. No submit to random PBTs or urinalysis as dedicated and pay fees. No bars or nightclubs. To go through the batter's intervention course as a part of your probation. You should do that sooner than later. Okay. Obtain and maintain employment, not purchase or possess firearm, ammunitions, or weapons of any kind. So, Mr. Claiborne, this is how this works. It's better if we don't see each other. The more I get to see you, the more I get to know you, the more I know that we've got problems and things aren't working out. And then I've got to look at, okay, maybe probation isn't working out. Maybe for safety of the public and the person, Miss Morgan, maybe that I should use that 45 days. And I don't want to do that. That's not my framework. So the less we see each other, the better. It just means you're doing what you're supposed to do and you're learning from this experience. It doesn't happen again. All right, sir? All right. I will sign the judgment of sentence. Do you have any questions of me concerning the judgment of sentence, Mr. Claiborne?
No.
All right. Anything else for the record in docket 24-00716? Ms. Wilson?
Nothing for the people. Thank you.
Mr. Sarks?
No, Your Honor, thank you.
Thank you. You're all set. You probably should stop at probation, the 5th floor, just to see who your probation agent is and get everything online. My court officer will walk you down there, okay?
All right, thank you.
Thank you.
Thank you, Your Honor.
Then, Mr. Johnson, I believe Mr. Brooks is ready.
And Mr. Henson.
All right, and Ms. Wilson's covering them.
Yes, that's
All
right.
right. All right,
And I
let's
have
go.
my instructions.
We have some instructions.
Okay.
We all have instructions.
Yes.
So let's do Mr. Brooks. So we're on the record in 24-01529. That is People of the State of Michigan versus Eric Brooks. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Johnson.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, appearing on behalf of Mr. Brooks, is present via Zoom.
And sir, you are Eric Brooks, is that correct?
That's correct, Your Honor.
All right, you can hear me all right, Mr. Brooks?
I can.
Thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Johnson was just appointed on this late last night. I'm guessing he doesn't have any discovery in this case yet. I would think that there would be a waiver of the 21 days in order to get that discovery. If that's not the way Mr. Brooks and Mr. Johnson are leaning to go, I would be requesting a just cause adjournment as APA Smith is not available for the current preliminary date.
All right, Mr. Johnson, how are we proceeding today? I know you were just appointed on the case. I think we just received your appearance, or we have not, so the court has not received your appearance. You may have one, we just haven't got it yet. Mr. Johnson, how did you want to proceed?
First, Mr. Brooks, do I have your permission to sign your name to the substitution of attorney so I can file it with the court?
Yes, sir.
Okay, Your Honor, what has been said is correct. At this point, I do not have discovery. It was my plan to take a signed copy of the substitution over to the King County Prosecutor's Office to this afternoon to get the discovery. I believed I could have been ready by the examination date, but the prosecutor is not going to be ready and the court's going to grant good cause. I just asked what dates are the court considering?
All right, but if I can adjourn for good cause. Okay, so we'll adjourn for good cause. So Mr. Brooks, you're not going to be waiving any rights today. Well, your attorney was just appointed in the matter, and we'll adjourn for good cause so that your attorney can get up to speed on discovery and any information he may need about the case from the prosecutor's office. And then I'm gonna give us a couple dates because I know Mr. Johnson, your schedule has some variables there, and so we'll provide you with a couple dates.
The first date was July 5th at 9.
July 5th, 2024 at 9.
Yeah, I have a previously scheduled vacation.
All right, let's try.
July 11th and
I'll be back from vacation on the 12th.
Okay, so post the 12th.
I'll get to it.
So post the 12th.
looking.
Might work, but I assume we done by the 10th.
I don't know, but we can, I mean,
I didn't say that. July 18th,
July 18th.
That works for me.
All right,
8:30.
so we'll set it for July 18th.
Your Honor, before we officially set it,
Yes.
this is a co-defendant case for the interest of judicial economy. Mr. Feigelson is here as representative for the co-defendant. I just want to double check that that works with his schedule too, so we can run it all
It
together.
does, Judge.
Okay.
All right.
I was gonna interject the 11th may not work for Ms. Smith and I. We have a trial together starting on the 3rd.
All right, so Mr. Feigelson, you represent the co-defendant Mario Horton in this case, is that correct?
Yes, he's on jail, in the jail right now.
All right. Well, that's Mr. Henton.
Yes,
right?
Your Honor.
Okay. Mario Henton. Well, let's go ahead and call both cases together. Yeah, that makes sense.
Your Honor, may I approach?
You may. All right, thank you, Mr. Johnson. So we're also on the record in docket 24-01528. That is People of the State of Michigan versus Mario Henton. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Fox.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mario Hinton, who's present by way of video conference from the County Jail.
And sir, you are Mario Henton, is that correct? I think we have the same problem. We can't hear the mic. Mr. Henton, raise your hand if you are Mario Henton. Thank you. All right, so Mr. Henton's identified themselves. We have something wrong with that mic, which we will email them on. That there's some technological issue because we can't hear that mic. Mr. Feigelson, you're also on this case, so this is set for probable cause conference in regards to Mr. Henton. Ms. Wilson, how are we proceeding today? Are we moving that to the same date?
Yes, Your Honor. I would be requesting if Mr. Henton's not prepared to waive his 21 days, I'd be requesting a good cause adjournment on this file as well. As I said, there are co-defendants in this case. There's going to be substantially the same evidence presented, same witnesses. So in the interest of judicial economy, I think we need to run these together.
Mr. Feigelson.
Your Honor, I'll leave it to the court. I do think if there's going to be a double exam, it would be prudent to have it on the same day. That the difference for Mr. Hinton as opposed to Mr. Brooks is Mr. Hinton is still lodged in the County Jail, but I would ask if there is an adjournment that this be credited to the people and we can address bond.
All right.
At some point this morning, Your
Honor. Well. All right, I'm gonna good cause. I'm adjourn this for good cause. Mostly because Mr. Johnson needs discovery on the matter. And this is a fairly, at least there's 2 felony counts on one, and there's 7 felony counts on the other. So I think that's good cause to adjourn so that we can put both together. I'm going to indicate that Mr. Feigelson may be ready to go on his client. I don't know if Mr. Johnson will be ready. Mr. Johnson indicates he is. I'm not going to have anybody waive any rights because I don't think the party should waive a right. I'll entertain a motion for reduction of bond on Mr. Henton, but we will set this for good cause to adjourn, and we will set for prelim on both files for that. It's July 16th.
18th.
July 18th at 8:30. July 18th at 8:30. So, and I'm in possession of your substitution of counsel from Ms. Schroeder to yourself, Mr. Johnson. So I'll place that in the file for 24-01529.
May I please have one copy back so I can take to the
Yeah,
prosecutor?
we'll give you a copy for the prosecutor's office. Let's see.
Should be 2 that I present.
Yeah, there's 2. Ms. Schroeder only signed 1.
Okay.
So we'll provide you with a copy. I don't see Sean here, but we'll provide you with a copy so that you have a copy to take to the prosecutor's office on 24-01529. And then Mr. Feigelson, did you want to be heard on bond on Mr. Henson?
I would, Your Honor.
Okay, you may proceed.
Thank you. I believe bond is
Mr.
present.
Brooks, you can log off, sir.
And you're all set, Mr. Brooks. Thank you for your appearance.
I believe bond is presently set at 250,000 cash. A surety, Your Honor. I know this is an allegation of serious charges, but I'd ask for a reduction today, Your Honor. Mr. Henton, it does live in the Detroit area. He does have a pending matter in front of Judge Dragonchuk where he was out on bond, has always appeared for those matters, Your Honor. I'd ask for a reduction in bond today, Your Honor. I do believe it's appropriate.
Thank you, Ms. Wilson.
Thank
Comment.
you, Your Honor. I think bond needs to stay where it's at. Mr. Henton does have another file already up in circuit with 6 felony counts and a habitual 4th offender notice. So there is an extensive criminal history here. He now has additional felony charges. I think there is a pretty substantial motivation here not to participate in the court proceedings if you were released. And I will note that he picked up these new charges while he's on bond in his other file. So clearly bond's not working for him. I think that bond's appropriately set here. I think in the interest of public safety, in the interest of judicial economy, it needs to remain where it is. So there are some assurances that we're proceeding and no additional offenses are being committed.
All right, the $250,000 cash bond that was set at the request that pretrial services indicated that some cash bond should be set. The prosecutor, as in the argument that the court just heard, defendant has multiple convictions for possession and delivery of drugs spanning over a decade. Felony bond for possession, delivery of drugs, firearms offenses. He was found with over 100 grams of narcotics, 2 military-style assault rifles. That's the allegation, and poses extreme risk of harm to the property, to the public. This crime was also committed while the defendant had other felony charges in circuit court. So I'm going to deny the motion to reduce bond for safety of the public and for fear of fail to appear. And I will see everybody on July 18th. Anything else for the record on docket 24-01528, Ms. Wilson?
Not for the people.
Mr. Feigus?
Nothing on behalf of Mr. Henson, Your Honor.
All right,
Thank you.
thank you.
Have a nice day, Judge.
Thank you, you too.
Yep.
Thanks. Yep.
All right. We're waiting for the court officer to get you a copy. So
I could try making a copy, but the last time I did it, I jammed it.
that's what I'm afraid of. That's what I'm afraid of.
Banned.
So once Sean gets up, we'll make you make a copy for Mr. Johnson. And then Mr. Henton, you're all set. Thank you for your appearance today. And then we will.
I'll be in touch soon, Mr. Henson.
Registered there.
We have admit all. Also.
Thank you for opening the court, Sean.
Pardon?
Thanks for opening the court.
All right, so we're on the record in 23-00696. That's Christian Wobu versus Sarah Hoffman. Will the parties please introduce themselves to the record? Sir, you are Christian Wobu, is that correct?
Yes, Your Honor.
All right, thank you. Is it pronounced it's pronounced Wobu?
Wobu, yeah.
Okay, thank you. This is the time set for this is your motion. As I see it, this is this was the time set for your motion. This was previously from a default judgment, and the motion was set aside because it took longer than 56 days to make the so the tenant did accept the move out date, which she has done, but she left other occupants in the building, and she's left some stuff in the building. And so you've come back with this to get an order from the court.
Yes.
Okay. All right. So I will grant the motion to set aside. And you should follow it up to me with an order, okay? An order that grants the motion to set aside, and then you're back to the eviction process. So we already have an order. We already have an order, a default judgment for, if I remember correctly, for a failed to appear. They were supposed to be out as of July of 2023. So you should follow it up with an order to evict Sarah Hoffman and all other occupants.
Yes, sir.
All right. You should submit that. I think that's a pro per, so you can do that. You can probably submit that to the civil department. That doesn't have to be an e-file, but you're gonna have to do an eviction notice to me so that I can sign it, and I'll wet sign it for you. Okay. Today is just to grant the motion to set aside. Based on the 56-day rule, you're over that, and I'll grant that motion to set aside it. You can do it twofold. You can give me, I grant your motion and an order of eviction. Okay. So I'll indicate for the record is that I grant the motion to set aside for plaintiff and plaintiff to file new order to set aside is granted. And then to come in and request the eviction, the order of eviction for the premises. And you should include all other occupants. Now, the items left that she's left, you can take that, you can put it into storage, or you can make it available to Ms. Hoffman if you have any idea where she is, but you should decide what you're going to do with the property, because after the eviction, after it's all moved out, that property will be considered abandoned. But I know a lot of landlords keep the property just in case somebody comes back for it. All right, so. All right. All right, so I've granted your motion to set aside. When I sign it, I'll grant your order for eviction, and you should put all other occupants on there. Although Ms. Hoffman was the only person on the lease, I believe. Yeah, but you want to make sure that everybody's out of there, and that should be our writ. What we're using. If I sign that, I'll sign that. So it'll be June 12th, right? Let me make sure I get the writ tape for you.
Okay.
It's still June 10th.
Okay. Okay, so if I sign it Monday, it'll be June 10th, right? If I sign it Tuesday, it'll be June 11th. All right. That'll be based on when I sign it. It'll be 10 days from that date.
Okay, so I'll try to do it on Monday.
All right. If you do it on Monday, we should still be on June 10th. Okay. Right. I'll indicate order is to follow. And that's all for the record. You're all set.
Okay.
So if you get it to the civil department, what order you need, order to set aside, an order for eviction.
Okay.
I've granted your motion, and then you can give them the order to have me sign.
Okay, thank you.
Thank you, Mr.
Okay, okay, thank you.
All right, Mr. Begg, you're here on the 0404953 case. That's the 04 case.
Yes, automotive credit versus Lori Jones.
Right. And on Tina's Galaxy, could you identify yourself for the record?
I'm Lori Jackson.
Okay. Did you used to go by Lori Jones, ma'am?
Yes.
All right. All right. This is the time set. So I'm going to, and David Jones is not with you, ma'am?
No.
All right. So we're on the record in docket 0404953. That's Automotive Credit Corporation versus David Jones and Lori Jones. Will the parties please introduce themselves for the record? Mr. Begg.
Good afternoon, Your Honor. Jay Baig, BAIG, P36820, appearing on behalf of plaintiff.
And ma'am, you are Lori Jones, is that correct?
It's Lori Jackson now. It used to be Jones, yes.
All right. All right, this is the time set for a motion today. And Mr. This is an objection to a wage garnishment, if I remember correctly. And ma'am, you were objecting to the garnishment of wages, is that correct?
Yes.
All right. So tell me the nature of your objection.
I never received any notification. I have been on disability for almost 20 years. So any type of communication that they've made with me, I have not received any notification about a judgment. The information that I got from them the other day, where they renewed this judgment in 2023, it's sent to an address that's not my address, that's not associated to me, and my wages are just being garnished. I had no chance or to discuss this or anything.
All right. So ma'am, did you want the opportunity to discuss this with Mr. Begg? My understanding is that they have proof that they've reached out to contact you in regards to this prior order that was signed by. This goes back to pre-Judge Alderson, most likely. The original was pre-Judge Alderson. I'd have to look. But would you like the opportunity to speak with Mr. Begg concerning the nature of your objection?
I am in a situation where, due to my medical disabilities, I can't make any more money than I already make to take on this debt. There's nothing else
that's not a defense to the debt, ma'am. There's already a collections issue, and the fact that you can't pay it is different than the matter that you want to pay it. I'm here to see if there's a meritorious defense to the garnishment, or if you have any explanation. You're here today, and you're indicating that you understand you have a garnishment, and that it's an older order, but that you simply can't make the payment. Is that correct?
Not only that, but when they renewed this garnishment, I was never made aware of it. The address that's on this renewal of this judgment is not my address.
All right, Mr. Begg.
Well, we've got proper renewals. The council would have done an address check. And not only an address check, but would have checked for bankruptcy, would check for whether a defendant is deceased in the military. They do regular what they call scrubs. And so this judgment's been renewed properly a couple of times. She hasn't expressed a valid objection. I mean, this is it's a wage garnishment. Wages aren't fall into any of the exemption categories as provided in the court rules. And also, I have this it looks like she filed a motion to dismiss as well, based on the reason that she gives is that this matter is over 16 years old. I'm unable to pay. I can't afford this. I wasn't given any previous notices. My wages were just garnished. Addressing that, she doesn't give really a valid reason to dismiss.
All right, and
this.
your representation today is that you provided valid notice on the motion that was set, the wage garnishment, and then any previous order.
Yes.
All right.
This address is not my address where they renewed this judgment for the last time. This is not my address. I can send in a proof with my lease, a copy of a lease where I was staying. This address is not my address where they sent the renewal of this judgment.
So Mr. Vega, how do you respond to the claim that that was not the correct address on the paperwork she received?
Well, she may not have filed a proper address change, because I know that council would have checked with the post office to verify the address.
I can submit a copy of my lease and a copy of my license. This is not
all
my
right. Well,
address.
let's set this. What defendant's saying right now, she didn't have proper notice of the reissue. Let's go ahead and set this for hearing. We'll bring all the documentation is. If Mr. Begg indicates, and he's indicating that you received proper notice and that you did not update it as indicated, then Mr. Begg is correct. You're responsible for the garnish wagement and any money that's being collected on this debt. Miss Jackson, if you can provide the court with any indication that that you provided an updated address, that may change things. Do you understand?
As far as an updated address, meaning like I went down and
that means like you bring it to me, you bring proof that you updated your address.
Okay, like my ID in a lease where I was staying.
No, you have to apply to the post. You have to apply to the mail so that you get the mail forwarded to your next address. You need to go and you need some verification so that I have an understanding that you were not aware that there was a collections issue, something that indicate that would claim a meritorious defense. Right now, you don't have one. You don't have any defense to this collections issue.
My defense is not being aware that this was in judgment. I did this.
Well, like that your testimony needs to be confirmed.
So I go to the post office and get verification that
I'm not going to tell you how to do it. Any way you can do it to confirm your testimony. I'm sure Mr. Begg has his own evidence that he's going to provide indicating that you've received service at the right place, that this collections issue has been updated. Regardless, I'm not just dismissing the case. This is a valid collection case, and you're indicating now that you did not receive an updated order, and therefore you didn't know about it. Well, now you know about it. So why don't we bring everybody in and we can work from there?
Okay.
All right. So we'll set this for hearing for bring in any evidence you want the court to consider concerning this proof of service. I believe that counsel has already not provided some indication that a posting was sent, it was updated, and that the mailing address was the last known address that they had on file. So if you did, so what I'm looking for is something to indicate that you updated the address and there was some type of mistake done, that it was sent to the wrong address. That's what I'm looking for, Ms. Jackson.
Yeah, okay,
And then-
because
and
I
then-
knew.
Go ahead,
I'm
Mr.
sorry.
Then just
Begg.
to be, yeah, then just to be clear, I'm just indicating what would be the normal procedure of the law firm and confirming address.
Correct.
Obviously,
I understand.
Yeah.
Right. I understand that you'd go through the address, but if this is a valid claim that it went to the wrong address and she had updated the address, then we can go from there and work from there. But right now, the onus is on Ms. Jackson to prove that she did not receive the valid claim. And so you should bring in any evidence, Ms. Jackson, you might have to indicate that you did update your address and so the correct address should have been a part of the file.
Okay.
All right, so I'll set for hearing. That'll be live in person, and that will be a hearing on June 25th at 2:00.
Okay.
So
Thank
that'll
you,
be
Your
live
Honor.
in person on the 6th floor of City Hall of Lansing. Right now, Ms. Jackson, what I'm looking for is something to indicate that you updated your address, or else I can only proceed on the fact that that address was updated and you were aware of this collections issue, and therefore you do not have a valid objection to the wage garnishment.
Okay. The only
All
thing
right.
I can do, I have a question.
All right.
So once I get this information to you that I did not receive, that the address isn't correct, what happens then?
I don't, then everybody will be here and we'll decide we still have a collections issue. You're still aware of it, but you'll have a valid objection to the wage garnishment. And then I can decide if the wage garnishment is not, this is a collections issue. So the order's already been signed. This is just a matter of whether you received an accurate notice or not.
Okay, so even if I didn't receive an accurate notice or not, I'm still responsible for this collection and I still have to be garnished for
You
this?
signed my understanding is you signed a joint and several contract. Right now, we're seeing if it's a valid objection to the wage garnishment.
And is the other party responsible for this as well?
Either party is responsible for all of it.
And they're not going after him because why?
I'm not going to tell them how to do their case. You signed a document which indicated that you're responsible for the whole debt. You can go to the other party and you can do whatever you want in order to make it joint and several liable. But joint and several means that you are responsible or they're responsible for the other debt, for the debt of the party, if either party chooses not to partake.
Okay, so I'm responsible for this collection and it's still going to remain at this 25% of my wages?
Yes.
So there's no working anything out between the company and myself.
That's between you and Mr. Begg, and you may be able to do that on the date on June 25th at 2:00.
You know, if she wants to go in a breakout room, I've got some settlement authority. If she wants to do a payment plan, I got authority to do that.
All right, ma'am, would you like to go in a breakout room with Mr. Begg to talk about this case?
Yeah, is that now? Yes.
Yeah, you can do it now. I can place you in a breakout room right now.
Okay.
Right, and if we come to some sort of an agreement, we'll put that on the record, Your Honor.
All right, so I'm going to have Mr. Begg. Can you do that? Mr. Begg and Miss Jackson placed in a breakout room, and then we'll come back and put it on the record. So you should each get a prompt to go to room 1. You should each get a prompt to go to room 1.
Oh, hello, clerk.
Yep, we're all here and we just brought back Miss Jackson. Mr. Begg, you had the opportunity to speak with Miss Jackson in a breakout room?
Yeah, so we're gonna do an installment payment order. Let me put the terms on the record.
All right.
Okay. Installment payment order, it's gonna be at a rate of $105 a month, with the first payment starting July 15th of 2024, and payments after that due on the 15th of the month until the judgment is fully paid. With respect to the objections to wage garnishment, the way that we're going to work it is any funds that have been withheld up until today are released to plaintiff's counsel, and any funds that end up being withheld after today get released to defendant. We can have the two orders done and sent out via the 7-day rule.
All right. Ms. Jones, was anything talked about by Mr. Begg that was not a discussion, was not a part of your discussions?
No.
All right. So Mr. Begg, you'll follow up with both those orders, one concerning the installment payments, the other any escrow, any wage assignment that's already been done with the terms of that agreement?
Yes, and then we'll do it under the 7-day rule. And what that means, Ms. Jackson, is that we're going to send a copy of both orders to the court and also to you. If those orders look like what we discussed today, you don't have to do anything. The court will sign it, and we should be set. Do we still need the June 25th date then, Judge, in light of this?
No, we don't. So we'll take the June 25th date off. And we'll indicate that the plaintiffs, the litigants met in a meeting room. An installment payment order was agreed upon, and it will be filed under the 7-day rule. And we discussed all of that, what that means with Ms. Jackson.
Yes. Okay,
all right. Is there anything else on record on docket 0404953, Mr. Begg?
Not on my end, thank you.
All right. Ms. Jackson, are you all set?
Yes.
All right. That's all for the record on that case. Everybody have a nice weekend.
Thank you too.
Thank you.
Maybe I hang up. I'm still mad.
You're all set, ma'am. You can leave the Zoom courtroom.